appeal in the matter of JVM children.
Yes, good morning, Ms. Miller.
Good morning, my lords. I appear for the appellant local authority. With me behind me is the social worker, the team manager and my instructing solicitor.
Thank you.
Ms Muse to my right represents the mother.
Good morning.
Is in present in court with her solicitor as well.
Yes.
Mr Malser represents the father, who is not present, but I believe may be watching the live stream. And Ms Watson represents the children by their guardian with her solicitor as well.
Yes. And was this a case in which the guardian is, as it were, watching
Yes,
herself as well?
She is linked on to the hearing via the live stream, my lord. And Ms Pilavki, my instructing solicitor, of course, represented the children at the first.
Thank you very much. Good. Can I just say, having understood who's participating, that as this is a case that, of course, involves children, no report of the proceedings is to identify the children or their families.
Thank you, my lord. We all propose to refer to the parties as the mother, the father, and...
Of course. Yeah. Can I clarify at the beginning? Does the appeal relate to 3 children or 2?
Just to 2 children.
Just the 2 children. I'm sure it has been made clear somewhere, but I missed where that had been said. So, taking the 14-year-old, we can say the appeal does not apply to her, and what has happened on the ground in relation to the arrangements for her?
She has now transitioned home back to her mother's care as of last week.
As of last week?
Yes.
Just a moment. Right. Yes.
My lord, I hope the court has received, there should be a core appeal bundle and an authorities bundle. Would your lordships prefer paper references or electronic references?
Well, let's see how we go when we get into the swing of it. It's always a good idea if they're the same, but I haven't yet checked.
They are not, my lord.
No. Well, we won't throw our toys out of the pram about that, but I should have said that we do appreciate, and I mean that the local authority has been has needed to have a change of counsel so that you're here today. But you I think will appreciate that from our point of view that it's not really manageable to do an appeal of this kind with, in a sense, counsel who's leading for the appellant not being present in the room. So thank you for picking up the baton. But right. So how would you like to proceed?
My lord, I'll be guided by the court to an extent. Obviously this is a rolled up hearing. It may be that it would make sense for me to address the court on essentially all of the substantive issues.
It would. Yes. I mean, what we will do is hear all the arguments that, in a sense, would have been appropriate in a world where permission had been granted, and then we'll decide retrospectively whether to grant permission or not.
Thank you.
So don't feel constrained in that respect. You started the main argument on whatever grounds of appeal we are working was the supervision order.
Yes.
So maybe we should start with that and see where that rests.
Yes, my lord. So if we start with the 2-year supervision order, it's not controversial between the advocates that there was no power to make a 2-year supervision order. I don't think anybody seeks to address the court otherwise. Certainly, the judge was asked, following the court's direction.
The judge?
The judge, first instance, was asked, following the court's direction, whether he accepted that that was a mistake. And I can take the court to that response that we've.
Well, we've read that. Yes.
Thank you.
I think the sequence of events seems to be that the judge handed down his judgment in draft several days before. Can we establish what date he actually handed it down? He shared it with the parties on a certain date in March, but could we be told, please, at some stage when that did come to the parties? Because it's apparent from reading it that there was an opportunity to make corrections. And I think the first thing, just so that we have the sequence, is it seems surprising that nobody picked up this point and asked the judge what he wanted to do about it.
Yes, my lord, I agree.
Yeah. And in a sense, as you were on the wrong end of an unlawful supervision order, particularly surprising that the local authority didn't raise it with the judge, having been given not just, as it were, 2 minutes on your feet, but several days of reflection.
My lord, my understanding of the position from the local authority's point of view was that it did not seem that the imposition of the unlawful supervision order was just an isolated error, and that it affected the analysis itself, and so it was considered that it was more of an appeal point rather than a mere clarification point. That's as a result of the points in the judgment where the fact of the 2-year supervision order is mentioned as a protective factor that would mitigate against risks, and I can take the court to those references if that would assist. But certainly that is my understanding of part of the reason why it was felt that an appeal would be appropriate.
Well, I mean, we're going to see in a moment where you're taking this particular ground of appeal, but we'll have to give some thought to that, because I'm not really sure that with the making of an unlawful order, we're anywhere near the grounds of clarification jurisprudence. It's not to do with clarification; it's to do with the fact that the judge has made a duff order.
Yes.
So, if you want to argue to us that you're in that situation, you're entitled to just keep quiet and appeal, I think we probably need to hear from you a little bit further, or we can move on.
I think, my lord, we can probably move on. That's certainly my understanding of some of the rationale behind it, but I don't.
So that's how it happened. But
yes.
you're not. I want to make sure I've understood you. You're not, as it were, seeking to say it was necessarily the right approach to it. It would seem, I think, to us that it would have been better just to somebody put their hands up, and I'm looking at others as well in that respect, and said, what about this?
My lord, yes, that does seem right, and certainly I think if, as I think clearly was considered in this case, that there were other grounds for appealing, then that's the mechanism for doing that. But certainly, if it appears to a party that the court is in the process of making an order which it has no jurisdiction to make, I would suggest that does need to be raised with the judge. Yes, so I don't take issue with that.
And are you happy with the thought? I don't know whether it's shared by any other party or either of my lords, but with the thought that we're not really here talking about clarification. We're here talking about jurisdiction.
Jurisdiction, yes.
And that council have got to tell judges if they immediately appreciate the judge has made an unlawful order.
Yes, my lord, I think that must be right.
Just as the mechanics, we have the order at tab 7,
yes,
which includes the 2-year supervision order, but at tab 6 we have a 1-year supervision order. So
yes.
How does that come about, or what has happened?
My lord, that's exactly the investigation that we were undertaking before coming into court. It appears that the draft order which provided for the 2-year supervision order was sealed first, and it then was followed with the 1-year supervision order, which I think was made following the correspondence directed by the court, but I think that's right, my lord.
Without any, has any order formally setting aside the 2-year?
No, my lord.
Or without seeking further submissions?
Exactly. So essentially, we've got 2 orders, both of which are sealed, which are directly contradictory of one another.
Well, the correct course would perhaps have been to correct the original order rather than to make a second overlying order, if it could be said that the original order should be corrected under the slip rule.
Certainly, yes, my lord, I do think that the original order should have been corrected. The original order, which has 2 years, is the sort of draft final order, and then the second order, which is only for 1 year, is the sort of court-generated supervision order itself. So I would have suggested that both need.
But I wondered whether, when I saw the page that my lord has referred to, the one-page order, whether the court had simply produced at the same time as the first order a second order, because supervision order is a standard order, which is always.
Computer says no. You mean?
Yes, yeah. I mean, the computer had corrected
Yes.
a mistake, but your belief is that this later order is a result, is the result of the judge's correction of his own mistake.
I believe so. I believe so.
My lord, looking at the portal, the correct order was uploaded on the 1st of April, but I know no more than that.
The single page.
Yes.
Well, that's a fortnight before it reached
I know.
reached me for the first time. So it might very well be a computer says no.
Yeah, my flippant comment may turn out to be correct.
Well, look, could you? I know that you're all very familiar with how to get at the archaeology of how documents have come backwards and forwards. We've asked you 2 questions so far, which I don't want to stop the proceeding in order for you to think more about them. But one is this question of when the single-page order actually was created, and whether, in fact, the court produced 2 orders at the same time. And the previous one is is what was asked before, which was what date the draft judgment reached the parties.
But it may be the portal. Don't forget, my lord and I have we're from the quill pen era, not from the portal era. So we don't understand how it works. But it may well be just automatically generated it.
My lords, we don't know, because there doesn't seem to be any correspondence alongside the lawful supervision order being made. Although extraordinarily there is correspondence around the non-molestation order that was made on the 23rd of March. Yeah. But I do know that the lawful supervision order was uploaded on the 1st of April.
1st of April? The lawful supervision order?
The lawful supervision order.
All right.
But Miss Miller, is it part of your case, thinking about it, that if a court decides to vary a term like this, a part of the order like this, in the way that happened, whether automatically or not, it should have afforded you an opportunity, or the party an opportunity, to make submissions on that, because, as you say, it's part of the overall protective package.
Exactly, my lord. Yes. You do.
The judge's document explaining that he accepted the error, corrected it, and some further comment on its significance, was a direct response to to my order.
Yes, that's right.
So we know that. Okay. Right. So, well, in the end, having surveyed all of that, where does the local authority end up? Is this really now historic, but feeds into your complaint about the overall protective package being inadequate? Is that where it takes to, or do you seek to advance this ground as a reason for the appeal on its own?
Well, I suppose to the extent that it's obviously not clear whether the order has actually been made lawfully or not, and whether it's actually been corrected. So if it's still in existence, then we maintain the ground on that fact alone. But if not, then it's the fact that that decision making informed the other process of risk assessment, and that the reliance on the unlawful order was one of the factors that we say undermined the judge's process of that assessment of risk.
Right. That's helpful. Thank you.
Mela, would you like me to address you further on what he said about those orders, or I can take you to the paragraph references?
Yes,
if that would be helpful in the judgment.
this is in the explanation of.
Yes. So I'll just deal with that briefly. So they are paragraphs 92 and 98 of the judgment, which are physical pages 75 and 76, and electronic pages 116 and 117.
That's the big discrepancy.
There is. I mean, I have to say, Ms. Miller, the order that I made has got a quite distinct reference to the rules about preparation of documents for this court. I mean, this is a major London borough, and we shouldn't have this situation arising. Remind me of what paragraph you're looking at now. 92.
So 92. The judge is discussing the protections which will mitigate the risk of domestic abuse reoccurring. And so that includes the experience of the proceedings, independent housing, family support, ongoing engagement with medical care, further supportive programmes, and then number 6, the making of a supervision order for 2 years with a robust safety plan. The second reference is over the page at paragraph 98, where in the penultimate sentence of that paragraph, the judge says, I am making a 2-year supervision order unusually to reflect the level of support that will benefit the children. The applicant will need to prepare and serve a suitable support plan. So we say that the judge clearly had in mind essentially a guarantee of 2 years of support.
But if support is needed in a year's time, you can apply for it.
Well, of course.
So,
yes.
I mean, paragraph 95 to 92 may be useful because you may no doubt have comment on other parts of those 8 protections as the judge described them. But I mean, had number 6 said the making of a supervision order for 1 year with the capacity to extend it for another 2, what's the difference?
The difference, we say, is that he explicitly makes reference to how unusual the 2-year term of the supervision order is, because it clearly is within his contemplation that that amount of support is what is required in this case. He doesn't say, I would be happy with it for 1 year, and then if it can be renewed, then that's fine. Obviously, that's what he said in correspondence subsequently. But it seems that he is actively relying on the fact of the supervision being in place for a long time.
Is there anything objectionable in itself in a judge saying there needs to be a quite high level of supervision for these children, and I'm going to make an order for the maximum period of 1 year, but in this case I would anticipate that an extension might be a real possibility?
No, I don't think there's any issue with that, my lord, and I think that's what the judge has said that he would have said if he had been corrected on it. But certainly that is not how I interpret what he says in that paragraph.
Yeah, right.
But it would be surprising, for first blush, in my view, it would be surprising if the whole edifice of this carefully constructed plan were to fall down simply because the judge thinks it's going to be a 2-year project rather than a 1-year project. If he'd expressed it in the way that my lord has suggested, why should this invalidate the whole idea of return home, the whole concept?
The reason for that would be, my lord, that obviously having 1 year with a potential to renew does leave the option open for there to be only 1 year of support. And if the judge considers that that would not be sufficient, then, and 2 years is the only sufficient amount of support that he would accept, then that's the difference I would suggest.
Well, yes, but how does that fit with nothing else will do? Or forgive the shorthand. How does, if the judge thinks, well, this is a way we can, I think we can safely return the child home, the children home. How then, and if it's possible to return the children home in this way, how can it be? How could it then be right for him to go on to say, well, because I can't do that under a 2-year supervision order, nothing else but adoption will do. I mean, you know, I'm using the hyperlink shorthand.
My lord. Essentially, the crux of our argument is that this is one facet of the overall inadequate risk assessment, which then led to an inadequate balancing exercise taking place. So whilst it's not necessarily that it's the one element that makes the entire plan fall down, when looked at holistically, we say that balance was ultimately done wrong as a result of this and the other.
It's symptomatic of his erroneous analysis, is how you're going to argue the case,
Now, your predecessors have left a range of possible ways of characterising the grounds of appeal. How many grounds of appeal would you like to address?
Well, my lord, the way I proposed to deal with it was in your lordship's order, it had been distilled down into essentially 2 grounds. So the supervision order being ultra vires, and then the overall analysis as having deficiencies in it. And I proposed to address it in that way, but taking the court essentially to 5 specific factors about the judgment, which in my submission are omissions or issues with the reasoning. Which
so these are matters which will, it doesn't matter, but would find some echo in the originally larger number of grounds of appeal. So we can now divide our thinking into, firstly, what do we make of what we just heard about the supervision order and how it was dealt with, and secondly, a comprehensive ground of appeal, which I'm going to take down in a moment, so once you repeat it to us, with 5 aspects.
Yes.
Is that the way you'll go ahead? That's
yes.
very helpful. All right, so just say it again, so we've got the way you'd like to put it in relation to the arching submission.
So the judgment is deficient in its analysis of the evidence, its welfare balancing exercise, and its reference to legal principle. There is, my lord, a world in which those could be seen as 3 grounds of appeal.
Well, I was hoping so, because otherwise we've sort of got three separate statements.
Exactly. So I think in terms of the grounds, I think it makes sense to think of it as 3, actually, now that I think about it.
Yes.
But in terms of my submissions, there are 5 themes I wish to draw out which engage all of those grounds.
Right. Okay. So we will see that you're saying that there's a deficient analysis of the evidence. Number 1, that there is a deficient welfare balance, and there is inadequate reference to legal principles. Number 3.
Yes.
And you will then support those propositions with 5 ways.
Yes.
Right. Okay.
My lord, so your lordships will have noticed from the my learned friend's skeleton arguments that there is some level of acceptance, I think, that there are some deficiencies in the way that the judgment has been set out. In particular, of note is the fact that there is no discussion of the parents' oral evidence and how that was weighed up
Can we
and no
just
sufficient.
keep this tethered? Which of your points are you making now?
I'm about to get to the first one. I just wanted to flag the overarching errors the overarching missing evidence that I'm talking about, and then it's the professional evidence. So the judgment is just silent as to names and analysis of professional evidence. The first point that I wish to make, my lord, is about retraction of allegations.
This is to do with deficient analysis.
This is to do with deficient analysis and the welfare balancing exercise.
So this is your first.
The first of five.
points. Yep.
The mother made allegations of domestic abuse against the father on 2 occasions that was heard about in the proceedings at first instance, in 2024 and in 2025. By the time that the mother was speaking to the independent social worker and the psychiatrist, she had retracted those allegations and was saying that she had made them whilst in a period of very serious mental ill health.
The first one, remind me, was a blow to the head, and the second one was a strangling. Or...
No, my lord. The blow to the head was the second one. Sorry, I was just trying to... That was the blow to the head. I'm very grateful to Ms. Muse. The blow to the head was the first one. And then there was the strangling with the fingers up the nose incident. That was raised in 2025.
I mean, two serious incidents.
Very serious.
I mean, those are the ones that you're referring to.
Yes.
Doesn't matter in which order, but that's just so we know what you're talking
Yes.
about.
And then so both the mother and father, by the time they spoke to professionals, were presenting the same case, that none of that happened. That the reason that those allegations were made were due to the mother's mental ill health.
So, my lord inadvertently interrupted you when you were making a point about that by the time the mother was speaking to the independent social worker and psychiatrist, she had retracted them and said she'd made them in what context?
When she was experiencing acute psychosis.
Right.
So when she was mentally unwell.
Thank you. I'm sorry I interrupted you.
No, thank you, my lord.
Yep.
Subsequently, the mother, at a hearing in August 2025, confirmed that in fact physical abuse did occur, but retracted those allegations again later that evening, after, she said, pressure was put on her by the father. But ultimately, when the parties arrived at the final hearing, the mother was again relying on her allegations of domestic abuse. She was saying that they'd broken up and that she'd been afraid, essentially. As my lord has pointed out, I wasn't at that final hearing, but I'm very grateful to my learned friend Mr. Melser for setting out in his skeleton argument the fact that the judge narrowed down the disputed allegations that he was going to deal with. And that is at, my lord, there's some slightly unconventional page numbering that I'm about to refer you to.
Give us paragraph numbers, probably.
In Mr. Melser's skeleton, paragraph 13E, which is page 48:5 in the bundle.
Yes. Yes.
Sorry, forgive me for chuckling. Rather, it's just 48 points, so it doesn't do well electronically, does it?
No, it's electronic page 55.
E, did you say 13E?
Yes, my lord.
Yeah.
Following hearing submissions on behalf of all parties, the judge made an ex tempore judgment which significantly cut down the disputed schedule of allegations to the following. An alleged incident of strangulation on the 15th of June 2024. An allegation that the father took the mother's phone to stop her contacting professional support. And discouraging the mother to be open and honest about the domestic violence in the relationship, causing the mother to be frightened and to rescind her allegations. And it's that last one that I wish to draw the court's attention to. In the judgment, if I could ask your lordships to turn to the judgment.
Before we leave this page, do you have any point to make about numbers 3 and 5. Point 1 and 2 there.
I do, but I will discuss them in a moment.
Yes. Where are we going?
In the judgment, at paragraph 18, which is on page 63, electronic page 104. The court mentions that the final hearing has focused on a schedule of allegations captured by the concern around domestic abuse. The learned judge does not refer there to having whittled down the allegations to those 3 disputed allegations. But my understanding is that that is what happened. Then over the page at paragraph 22, the judge cites this issue of withdrawal of allegations. So the concerns around domestic abuse include a concern as to the first respondent making but then withdrawing allegations. The applicant is concerned that this process reflects elements of control and or lack of insight on the part of the first respondent. The second respondent, whilst admitting an item of physical abuse, argues the broader picture of allegations is reflective of the first respondent's poor mental health and related confusion on her part. He argues when she returns to better mental health, she then withdraws the allegations. That, my lords, is the last time that this is mentioned. The section where the judge addresses his findings on domestic abuse is from paragraph 38 onwards. In this section, it is not mentioned. There is discussion of the agreed incident of the eye bruise at paragraph 39. There are findings that he made about the wider context of the relationship. At paragraph 43 and 44, he discusses the strangulation. And at paragraph 45, he discusses the mobile phone coercive control. But at no point does he mention the allegation which he had identified as relevant of the father putting pressure on the mother to rescind her allegations and her doing so out of fear.
Well, why was he not asked to do so?
My lord.
Well, it isn't. I mean, you stretch your hands, but I mean, here we are in peak clarification grounds. It's the responsibility of the parties to draw to a judge's attention if he's failed to deal with the point. If it's considered important, it's not for the party simply to turn up in this court and say, look, he hasn't dealt with it.
My lord, I don't know why it wasn't raised. The issue that flows from this, my lord, is that the court also didn't engage with the professional concerns about the retractions. Those concerns had been expressed by the independent social worker at paragraph. I'll give the court these paragraph references, but I won't necessarily take the court to each of them. Paragraph 5.91 and paragraph 5.93 of the independent social worker's report.
In where? In where?
In the independent social worker's parenting assessment.
Yes, you have to give us some page numbers.
Sorry, that's page number 137 or electronic page 178.
178.
Paragraph number, please.
Paragraph number 5.91. Sorry, it's 5.93. No, I'm sorry, my lord, it is both. So 5.91, the independent social worker notes that the mother is shouldering all the responsibility for reporting the domestic abuse in an attempt to shift the blame from the father. However, despite the deterioration in her mental health, the account that she provided remained consistent. And then at the bottom of that page, 5.93, the independent social worker says that the mother repeatedly attributes her past allegations, including highly specific and disturbing accounts such as strangulation, threats to kill, and demeaning name-calling, to episodes when her mental health was severely compromised. This undermines the credibility of her previous reports, but limits her capacity to meaningfully engage in any safeguarding planning. This is something, again, that the judge doesn't deal with. The psychiatrist also, in his report at page 91, electronic page 132, comments at paragraphs 3.27 and 28 that the mother continued to deny any violence from the father, and the psychiatrist was very worried, speculating that the reason for doing this, the withdrawal of the allegations, is that she did not want the father to go to prison and was concerned that she was putting his needs first.
Would you just give me those paragraph numbers again?
Sorry, that's paragraphs 3.27 and 28, my lord. And these are also concerns that were shared by the social worker and by the guardian in their evidence as well. The social worker raises it at paragraph 3.4, which is at page 180 or electronic page 218. That is not the right.
Could you just say that a little more loudly?
Sorry, that's not the right page reference anyway, my lord. It's paragraph 3.4 on page 180, which is electronic page 221.
Thank you.
Where the mother's continued involvement with the father and retracted allegations raises concerns regarding her ongoing vulnerability to domestic violence and ability to protect her children from physical and emotional harm. My lord, I did have a page reference for the Guardian's report to this as well, but somehow it's got deleted from my note.
Don't worry, read it.
I do
Well, we'll find it.
apologise.
But I mean, sense, where is this going? Is it your suggestion that the judge simply forgot that the mother, as a victim of domestic abuse, follows a familiar pattern of making allegations, withdrawing them, reinstating them, withdrawing them? I mean,
It doesn't.
is that what the local authority's case is?
My lord.
Or is it that his homework loses a mark here because he didn't specifically mention this feature of the relationship?
My
Not
lord,
having been reminded of it.
I wouldn't suggest it was necessarily the former, because he does make mention of the withdrawal in his judgment. It is difficult to tell from the judgment because he doesn't address it specifically, he doesn't make any findings on it, whether he had it in his mind at all. And crucially, my lord, where this takes us is that the court was making supervision orders and was putting in place a protective structure which to a large extent does require communication, openness, cooperation with the mother, and fails to address, in my submission, the fact that this dynamic existed which led the mother to tell professionals that she wasn't actually telling the truth when she made those allegations, that she'd obviously, that it didn't happen. There's no analysis of to what extent that might undermine the protective measures that are put in place. It simply doesn't feature in the analysis.
Can I just track this through
Yes.
in the way that you have, helpfully, and see if you're right about your submission? Paragraph 22 is where you say it's the last time the judge expressly mentions this particular concern about a pattern of retraction, of allegation and retraction.
Yes.
What he says there is, the applicant, that's you, is concerned that this process reflects elements of control and or lack of insight on the part of the first respondent. Is that a fair summary
Yes.
of a crucial part of your case?
Yes.
That's really what you say, have I got this
Yes.
right? He doesn't deal with. And he doesn't mention that in terms, again, you say in his section headed helpfully the conclusions with respect to domestic abuse. But he does he not, when he gets to his conclusions at the end, I'm looking at paragraphs 87 or 86 onwards, recognise the existence of a risk of domestic abuse, and in particular, he says in paragraph 88, I am satisfied the first respondent has reflected and her position is genuine, not amounting to lip service about the concerns. And then over the page, the risk of domestic abuse remains, but it must not be overstated. Doesn't he deal, if not in express terms, with what you say in paragraph, he quotes you as saying in paragraph 22, but he does deal with the lack of insight point, which underpins it, doesn't he? Your case is that this pattern reflects a lack of insight. Isn't he addressing that in paragraph 88, that she has reflected on her position is genuine, not amounted to lip service to the concerns?
It does not mean she's not vulnerable to the second respondent.
Yeah.
There are two points to make that, my lords. Firstly, it's not clear from the judge's analysis on what basis he is satisfied that this is genuine, not amounting to lip service. That isn't explained. I can't find an explanation for that anywhere. There's no discussion of the evidence that was given by her or by any of the professionals and how he's reached that conclusion. So firstly, I would suggest that to the extent that it is addressed, it is still deficient. But secondly, in my submission, this doesn't address that dynamic of fear. It may well be that the mother has reflected and that her position is genuine in respect of acknowledging now that there was domestic abuse. But in my submission, to suggest that then can be extended to, and she has understood that dynamic of fear and what led her to tell the professionals that she had made all of those allegations up and has all of this other insight that allows me to be satisfied that these issues won't arise again and therefore that the supervision order is workable. In my submission, that simply isn't in there. I don't see that.
I know you weren't present, of course, at the hearing, but is it local authority's case that there wasn't evidence before the judge on which he could properly reach the conclusion he does in paragraph 88?
About the sort of genuine.
As I read it, I'm trying to think of this. It's as I read it, he is there addressing your point about lack of insight, and has concluded that she has reflected. It's not just lip service, and that doesn't mean she's not vulnerable. So, sorry, you're not helping. Is it your case there wasn't evidence before him of which could lead him to that conclusion, or that it's just not referred to?
Might I turn my back just to confirm that, my lord? Because there's no way for me to know from the judgment. So if I might just check if we consider that was actually raised at the hearing.
Of course. Yeah, sorry, I was being quick.
I was just pointing to 1881.
Yeah, sorry, I'm up. Yes.
Yeah, it's in the same terms.
My lord, I am told that as far as we consider there wasn't evidence that was given about this process of withdrawal.
The process of withdrawal.
The withdrawal of the allegations and that dynamic that
Well,
led
there must
to
have
it.
been. I mean, if we're here thinking about it, then the mother must have been questioned about it.
Indeed, must have been challenged by the local authority.
Yes, Miss Muse was there.
Central to your case.
My Lord,
We'll call a witness.
Forgive me, my lords, and in fact, the mother deals with this aspect of the case, the making of allegations and retracting of allegations, in her 2 witness statements, which
Yes.
are in the bundle, and she deals with it at some length. She was asked about the withdrawing and of allegations, and I appreciate that one doesn't want to give evidence, but she confirmed what she has said in her statements, that she was afraid at the time. She believed that if she had reconciled with the father, she had a better chance of the children returning to her. And of course, crucially, my lords, which is contained in her statement, she started work with the Freedom Programme in September.
And can you confirm, because you were there, was she questioned about this by Miss Miller's predecessor?
Briefly, she was.
All right.
My lords, in the event that it was then aired before the judge in the final hearing, it does make the fact that there is no, especially in the context of the fact that the judge does specifically go to all of the other findings that he makes. He deals with each of them in turn, and then purports to make an order that does rely on the mother's engagement with professionals. It is, in my submission, a glaring omission that there is no reference made to this dynamic, and that it goes further than simply forgetting. It's that this didn't form part of his analysis, as far as I can tell, and that I'll come to the work that the mother had done in a moment, but in respect of whether she had reflected on what in my submission, it's really unclear what he's actually talking about here. Of course, there is vulnerability discussed, but it doesn't then go further in the analysis.
But what I mean, the job of a judge is not to be a seer. The job of the judge is to look at particularly from the point of view of the children, to decide what the levels of risk are to them. Paragraph 81, in relation to this aspect of the case, makes it quite clear that the judge accepted that this was not a risk-free placement.
Yes.
Returning any of the children, particularly the smaller ones, to the judge. I mean, isn't that the point? He accepted the case that there was a level of risk to the children arising from domestic abuse and also from other sources. But I mean, in the end, I'm not quite sure where this particular point goes, and I'm continually having the feeling that if this was, as you described it, a glaring omission, why did the local authority not ask the judge to correct it?
That's right.
Or was it something that was just one of the things that had been heard during the days of evidence, which the judge didn't feel the need to bring down front stage when expressing his overall views?
My lord, I think if the latter were true, then I would find it difficult to square with the fact that he identified it specifically as one of the 3 allegations that he was going to deal with, and that it is one of a number of deficits in the judgment that mean that it's absolutely right. The judgment mentions multiple times that there is a risk, but what it doesn't talk about is any analysis of how he's actually really, or insufficient, I should say, analysis of how he's arrived at deciding exactly where that level of risk falls, and this is one of the elements of that that we say is missing.
So have we done retraction?
We've done retraction.
Right, was that point one?
That was point one.
Right, okay.
Point two, my lord, relates to the other findings that are made in the other
One and two.
Yes.
Those were the two that you passed.
The two that I passed over, and my lord, I'll take you to the section that deals with this, which is from paragraph 38 onwards.
So how should we headline?
So the
Second
headline
point.
for this one would be overall seriousness of the domestic abuse.
Is this for two incidents?
This is, well, he makes findings on several matters, but it's the two disputed incidents and the one agreed incident. And the one agreed incident, which was the eye bruise. That's not mentioned in Mr. Mills' skeleton argument because that was agreed. That was not a disputed allegation. The father accepted that one. That, in fact, is the first allegation, which is dealt with at paragraph 39.
Yes.
Where the judge says the second respondent accepts one occasion which left the first respondent with the bruised eye and the picture placed before me. I consider it relevant this admission was only made as the evidential picture became clearer. By the time the evidential picture was complete, the allegation was difficult to refute. I'm left concluding the second respondent's willingness to be open and transparent is a function of the evidential case he faces rather than insight and reflection on his part. So we obviously there have not only dealing with the agreed finding that wasn't contested, but also some findings about the way that the father has approached this, because obviously throughout the proceedings he had denied it until a picture was put forward that made that difficult. I don't have any issue with that. The second paragraph 40. I do not wholly reject the notion that there were surrounding circumstances that the second respondent considered were provoking of him, but I do not find these could excuse his behaviour, and particularly so given that this was acted out in front of the children. I accept, as I note above, that the first respondent's fragile mental health interacted poorly with the second respondent's own impulse control and judgment. The reference to above is to paragraph 37 on the same page, where the judge essentially makes a finding that the domestic abuse and the mental health are interconnected issues, and that when he describes them as bi-directional, he means that one leads to the other and the other leads to one. Firstly, again, there isn't an explanation of how, by reference to the evidence, this conclusion has been reached, by an explanation of what the judge heard and why he forms this view.
Sorry, which view are you referring to?
So this is about that there were surrounding circumstances that were provoking in a way, i.e. I think he's referring to the mother's mental health, that was a sort of exacerbating factor when it came to the domestic abuse. My lords, I would submit that a finding like this would require a bit more explanation, because whilst the judge is clear that he doesn't mean to excuse the abuse, it does bump up against that idea that there is something that the mother was doing that was contributing to this happening to her. And I would just suggest that that's quite a serious thing to say, and I'm not clear how he arrived at that conclusion and on the basis of what evidence.
And all he actually says is he doesn't wholly reject it.
Yes.
But aside from that, where would this lead?
This theme arises on a couple of occasions throughout the judgment, essentially to go to the fact that, well, if the mother's mental health is stable, then there is less of a risk of domestic abuse arising, which I find a little troubling as a direct link. And
Well,
it,
what was the local authority's case?
on this point exactly, my lord, I'm afraid I don't know. I'd have to check.
But I mean, in a sense, it's essential that you do know that, because if I mean, this is quite a subtle area of assessment for the judge, that he saw these people and he heard the professional witnesses, and this was what, speaking for myself, is a perfectly normal process of assessing relationships and the reason why things go wrong with them. But I mean, is you know, what we need to be able to do is to contrast what the judge made of it with what your authority said it was. What did your local authority say was going on here?
Well, in terms of the findings that were sought, it was number 6 in the schedule, which was that the mother's vulnerability to poor mental health puts the father in a position of trust and control in the relationship, and that the father's abuse of the mother's vulnerability to indicate she was confused or hypersensitive aggravates the behaviour and increases the
page are you reading
impact on the
from?
family. So this is in the supplemental bundle.
Thank you. Yes.
But this is your case.
That was the local
But the
authority's
judge,
case at
the judge pretty well accepts
Accepted
that, doesn't he? What, he just puts it in a different way. The last sentence of paragraph 40, I accept, as I note above, and I don't know where that takes to, but it's all the way through, really. I accept that the mother's fragile mental health interacted poorly with the father's own impulse control and judgment. Yes. And then paragraph 45. Actually, I think this, no, I read it, I think this may fit in with your first point about no reasoning about insight. Elements of control would have been an aspect of their relationship, your case. I don't set it at a particularly high level. You would disagree with that, but it's open to him to find, isn't it? It was a feature of their relationship. I find a combination of his character and her vulnerability resulted in controlling outcomes. At the moment, Ms. Miller, I've got a very clear idea of what the judge's conclusions were about domestic abuse. Aren't they clear?
My lord, that one is certainly clearer. I'll take you to the next one, if I may. Firstly, a matter that I don't take issue with is paragraph 41, which is where the judge essentially makes a finding that the eye bruise was not an isolated incident. He doesn't go as far as to give many more specifics about what those incidents would have been, other than that it would, at the final part of paragraph 41 on the start of the next page 67, that it has a broader domestically abuse landscape, including verbal abuse and belittling as alleged. So that's a finding, again, that was absolutely open to the judge to make, and I don't say it wasn't. Again, similarly with 42, this relates to the father's conduct in respect to the social worker and sending of the message. Again,
Yeah.
absolutely open to the judge to make that finding, and no issue there. My issue is with paragraphs 43 and 44, which is the strangulation. The judge says he's less clear as to the incident of non-fatal strangulation. I accept this as a serious allegation, and then in paragraph 44, he says, I find the second respondent did have his hands in proximity to the first respondent's neck on this occasion, and I also accept this was done in such a manner as to intimidate and scare her. I reject the notion that this was simply an act of holding her, but my findings do not extend to strangulation in the sense of pressure being exerted, as understood by the word strangle. In considering this allegation, I reflect on the limited evidence given as to detail of the event over and above the label used and the fact something of this sort occurred. Neither the first nor second respondent were examined in such a manner.
We can read this for ourselves, but what's the point you wish to make?
So the issue is, firstly, my lord, I can't understand the basis on which that finding was
Well, he
made.
saw, he heard evidence.
Yes,
He heard evidence from the parties about it.
But what evidence? What did the mother say? What did the father say? What was preferred and why?
Well, your authority was there. It knows.
Well, leads me to the second point, my lord, which is clearly the evidence that the judge heard was in his mind not sufficient to allow him to get to the...
What are we talking about here? Are we talking about whether this repellent bit of behaviour included pressure being put on the neck, or simply being held by the neck? Is that what this is about?
Yes.
The degree of seriousness of this
Yes.
appalling event?
Yes.
And that this is a brick in the wall to what should happen to these children for the whole of their lives?
Yes.
All right. So I've got the point. So is that the incident of strangulation?
That's the incident of
I mean, it's very clearly, in my view, for my part, very clearly expressed in paragraph 44. The problem was that the judge didn't hear much evidence about it. He's gently critical of the way in which the witnesses were examined about it, I think. Neither the parent was examined in such a manner as to enable me to form a clear view as to the exact mechanism of the event. He had to do the best he could in those circumstances, and he concluded he didn't find the evidence was such to make him able to find an actual strangulation, although it was an act intimidatory in nature.
Yes.
And has preferred the broad evidence of the mother over the father.
Yes, my lord. The issue there being, of course, that it would be open to the judge to say, I haven't heard sufficient evidence on this very serious allegation to enable me to make a finding, to flag that, essentially.
Isn't that what he says? It's more or less what he says in paragraph
But
40.
before that point.
He's made a finding of there being an assault on the mother, which he shouted and screamed, and he prefers the mother's evidence over the father's. I mean, as a local authority, I'm wondering what more you need. I mean, we're not concerned in this court about the minutiae of particular incidents, however serious they are.
No. The overall point, my lord, that I wish to make about this is that actually the findings that the judge has made are serious, as
yes, and he thought they were serious.
They're absolutely serious. And so I then just want to contrast with his ultimate view at paragraph 87.
Sorry, you drop your voice when you give a paragraph number.
Paragraph 87.
Thank you.
So in paragraph 87, the judge then essentially summarises his view about what has happened and says, I have found events of domestic abuse in what would have been challenging circumstances. Whilst the events were serious, they were not all pervasive, and I should not allow relatively limited findings to colour the future life of the children in a disproportionate manner. So, my lord, the point I want to make there is I'm not clear how he has got to that conclusion, having made the findings he's made. The findings themselves are serious, and he has made findings that there was control in the relationship, that these were not isolated incidents, and some of them are really, really serious. In my submission, to then reach the conclusion that, well, it's not all pervasive and the findings are limited, I would just suggest that needs more explanation.
All right. Okay, that's that point.
That's that point. The third point, my lords, is the analysis of the risk of the domestic abuse arising again. After making these findings, the judge then talks about positives, which is at paragraph 47 of the judgment on page 68. I can summarise these positives as essentially being the support of the mother's sister, stable being in place, the father being out of the country, and the mother's engagement with work and mental health services. Firstly, to deal with the matter of the sister, what isn't dealt with when discussing the proactive support that her sister can provide is the fact that within the proceedings, whilst the mother and the father were presenting as a couple and the mother was denying that that any of those allegations were true, it was her sister who she pushed away because her sister was the one who'd supported her to make the allegations. And so for some period of time, that relationship wasn't
He doesn't refer to pushed away. He doesn't say the mother pushed the sister away. He says the sister pulled away historically. So, pretty technical point. I mean, what's your insofar as it he recognises that when the father's on the scene, the sister isn't a protective element. That's what he's saying, isn't he?
But I think it goes slightly further than that, my lord, in that it's not that the sister pulled away of her own volition, it's that the mother was responsible for that dynamic as well. That it's that when the father has come back around, the mother has rejected the support of her sister.
Well,
that's how it seems to me.
For my part, I don't think that's with respect to tenable submission. The judge says, I recognise that this sister has pulled away historically when the first respondent has, I'm emphasising, chosen to be with a second respondent, contrary to the sensible judgment of the sister. Isn't that really reflecting the point you're making? Not quite in so many words. He doesn't, what isn't it?
I think it may come down to a difference of interpretation, my lord, because I don't consider that deals with the point that the point that I've made.
Well, what is the point? I'm sorry, I haven't
Sorry,
understood. I haven't understood what more is expected of a judge in this situation.
Well, to address the fact that it's the mother who essentially had participated in that support not being available to her. I would just suggest that that's a part of that analysis that's missing.
Right, so that's that point.
That's that point.
So,
housing, obviously, stable housing is a positive, and I don't suggest that he sort of elevates this to any sort of inappropriate level, but it is, of course, just one part of the picture. Then I come to the mother's engagement with work. The judge says here that the mother has been willing to engage with professional support through programmes around domestic abuse and mental health. What isn't addressed here or anywhere in the judgment is what the independent social worker recommended in terms of work to be done. Firstly, that there should be a DV Act assessment.
sorry.
That there should be a DV Act assessment. The judge had made the decision. There was, my lord, there was an issue with funding, I believe, and that by the time it came to making a decision about whether to proceed with that assessment, the judge felt that due to those issues with funding and the delay that it would cause, that it shouldn't be progressed with.
So tell us a little more about what that assessment is.
So essentially, the independent social worker was suggesting that before even contact would be progressed, that there should be an assessment of both parents, specifically looking at domestic abuse, their dynamic, and the risks that would be involved.
When you say
for
before
children.
contact could be progressed, from what? Before there could be any contact, or before there should be more contact, or what?
I think before contact could be progressed in terms of sort of overnight unsupervised contact. I'd need to check that, but it definitely was before a progression of contact.
For mother?
For both parents, yes.
Can I just be clear on one point? The point the judge is making here is that there's good evidence of the mother being willing to engage.
Yes.
So does the fact that this assessment hasn't been carried out reflect on the mother's willingness to engage?
No, it doesn't, my lord. And clearly, so the mother did engage with the Freedom Programme and had completed it by the time of the final hearing. What we don't have is the other factor that the independent social worker was looking for. Sorry, I haven't given you the page numbers. This would be page 159, just for your reference, my lords. But that there should be completion of work and evidence of sustained progress and capacity.
But what's the consequence of that? I mean, as I understand it, this was not a course that was offered to her.
No, that's
how in that case does this feed into the debate? Is it that the proceedings ought to have been adjourned They'd already been going on for 50 weeks or something of that sort. Should the proceedings be adjourned in order for somebody to gather together the money to offer her the course?
Well, certainly.
Otherwise, where does it go?
Well, the judge doesn't address that in the judgment, but for both in terms of the further assessment, which would look at the issue of domestic abuse between parents in much more detail and how it would affect the children, but also in terms of assessing the progress that the mother had made through that work that she'd done.
But it could only lead to an adjournment, couldn't it?
Yes.
Because you can't have an adoption order for these children, a placement order for children, when you don't provide a parent with a course that you say she's got to have before you can assess her.
No, my lord, and the local authority weren't seeking an adjournment.
No, who would provide this course?
It would
if anybody.
It would be by DV Act. I think they are an organisation in and of themselves.
Yes, and who would pay for that?
I don't I'm being told slightly different information, but I think we would suggest it would be joint.
Joint. Sorry.
No, it's not an assessment.
Joint.
It's not. It's work, isn't it?
And my lords, the legal aid authority specifically refused authority to carry out that piece of work.
Yeah.
They don't pay for work, do they?
They
pay for
wouldn't
assessment.
pay for it.
That's still the general case, as it was years ago.
I'm sorry. My understanding was that the issue was with the prior authority from the mother's application for the legal aid agency, that hadn't gone through, and that was why the work didn't take place. So it was going to be joint.
Right, now I hadn't picked this up, this particular point. It's mentioned in the grounds of appeal previously drafted, but because, I mean, did the local authority ask for an adjournment of the proceedings?
No, we didn't.
No. So this was considered by the independent social worker to be the course to be taken,
Yes,
and it wasn't taken.
that's right.
Right, so where does it take us?
I say that the combination of that and the fact that what the judge had before him was evidence of the mother's participation in the Freedom Programme. But what he did not have was the evidence of sustained progress and capacity for change that the independent social worker said that she would be looking for. And that's not addressed, and I would say that is as well a gap. Because in the mother's final statement, she explains that she's done the course, but she doesn't actually explain what insight she has gained through it. I can take you to that. It's electronic page 259, my lords. Which is page number 218. At paragraph 14, she says, "I do not accept what the parenting assessor has said about me. I've come a long way and went on the Freedom Programme and have accepted there is domestic abuse." But what the court doesn't have is evidence that work has bedded in, what lessons have been learned, and therefore how a finding that the mother is going to be able to act protectively towards the children is supported. That in my submission is missing.
So the work should have been, that was you say, a prerequisite for any decision to return the children.
Yes.
It does strike me, I have to say, as being incredibly unfair to the children and to the mother that after a year after you've taken proceedings, the future is going to be decided on the basis of a course that she's not been offered. She having undertaken the work that she has been offered, apparently, according to the judge. I mean,
I think for me, my lord, the weight perhaps of the second part of the submission of not knowing what the mother's insight is as a result of that programme is the one that I pursue more forcefully.
well, take us. I mean, this is not meant to be a trick question, but I don't have the same grasp of the evidence, detailed evidence that was provided to the judge that we have statements in our bundle from your social worker, certainly an updating statement, a final statement, and so forth. Can you take us to the part of the evidence that emphasises the importance of this further work on top of the Freedom Programme? Because I've found places where the Freedom Programme is referenced.
I'm very sorry, my lord.
No, don't
I
worry.
turned my back without asking. I'm told that because it's a risk assessment rather than a parenting assessment, that it's therefore slightly different in terms of what would be expected, and so I don't think it is addressed in the final statement.
I mean, I'm looking, for example, at the final social work statement. It didn't turn out to be, I don't think, but at electronic 183, I can't help on paper, but at 3.28 of the final statement, tab 14, where there's a reference at that paragraph to the Freedom Programme and to other work in this respect, but in a sense, it's an opportunity for you to say, in being critical of the judgment, that the judge is rejecting some proposition that you had put, and at the moment, unless you can point us to this, it seems to be that the picture is that there was no case put by the local authority that this was essential, and that even if it had been thought to be essential, there wasn't a course for the mother to do.
My lord.
It's all right, Ms. Muse. Can we just keep going from there?
My lord, I think it's right. I don't think that there was any case put forward by the local authority on that basis. But what I say the judge should have done is, because there is no explanation for why he rejects any of the professional recommendations, and that is one of the professional recommendations. That's as far as.
Well, if you get 4 or 5 witnesses of professional sort, they will make recommendations and so forth. But in the end, this doesn't seem to have been amongst a number of issues for the judge, because he religiously sets out what the issues he has to decide are. I also have to decide whether to adjourn this case in order to make further efforts to get a course for the mother to go on, so we can know more about her attitude to domestic abuse. It simply wasn't an issue for the judge on what I've read and heard.
Certainly, my lord, looking at, obviously I don't know to what extent there are submissions made on it, and I simply am not in a position to be able to assist there.
All right.
If I move on then briefly just to the father's
Is this on risk of recurrence?
This is still on risk of recurrence.
Yes. Father.
The father's engagement. Paragraph 79 of the judgment. Which is page 73. The final paragraph of final sentence of paragraph 79. The second respondent has indicated he's open to a programme of work, but I doubt the same will be either available or engaged with from Grenada. That, I believe, was a change in position from the father, who had previously said that he wasn't.
Well, the social work statement you just looked at says he wasn't interested at all.
Exactly.
So what point arises from this?
So the point that arises from that is firstly that this is the reference, as far as I can make out, to what efforts are going to come from the other side of the equation, so from the father's side. And the reason I raise this is because it goes to my next point, which is essentially how likely is it that these parents will come back into contact. The judge places quite a lot of weight in my submission on the fact of the father being out of the country now. This is dealt with firstly at paragraph 47 in the positive developments paragraph I took the court to earlier, where the judge says, I note that he's out of the country. It's unclear as to his potential to return at will as he left following overstaying his last visa. Again, it's not clear to me whether there was any suggestion of a ban on returning. That doesn't come across, but this does come up several times in the judgment. Is essentially, well, the father is no longer in the country and therefore the risk is reduced. The father, as far as I understood it, as I understand from the evidence, was that he would normally visit about every 6 months or so.
Yeah.
That he could well try and come back. That there could be an attempt to make contact virtually. All of these sorts of factors could arise. And the crucial thing that's missing in my submission from that part of the analysis is how recent the separation was. In the context of their relationship, which was some 15, 16 years, by the time of the final hearing, it had been a matter of some months when the parties had been separated. And they had separated on previous occasions. The judge doesn't, in my submission, analyse what that means for the stability of this separation moving forward, and doesn't address why, notwithstanding the fact that it is a relatively recent separation in that context, why he is still satisfied that the risk is reduced. He makes multiple references to the risk, but in my submission there just isn't an explanation of how he gets there.
Well, paragraph 89, Miss Miller, might be the answer to your concerns. The risk of domestic abuse remains but must not be overstated. It's not a knockout blow simply by reason of its continuing potential. And then we have, it's less likely because of the mental health concern is less likely to arise in the context of an otherwise stable life. The mother's been open to engaging with helpful interventions and has evidence of genuine willingness to continue. Such work will tend to reduce the impact of future misbehaviour, and I don't overlook the geographical dislocation. So those are the 5 factors he takes into account in that paragraph in concluding that although the risk remains, it's not a decisive, my word, decisive consideration.
Yes, my lord. And the point that I make is that missing from that analysis is any consideration of exactly how short term in the context of their relationship this separation has been, what that means, and actually the risk of them coming back into contact. I just do not see an analysis of that likelihood.
Okay, we've got that.
Thank you, my lord.
Right. Yes?
Then finally, just on this third point, just before I finish, the mitigation measures that the judge set out at paragraph 92.
Is this to do with risk of recurrence?
This is
Right.
to do with risk of recurrence, yes.
92.
The final point on this. I say that the protections that he set out, firstly,
This is a whole other point, isn't it? I mean, you're dealing with the risk of recurrence of domestic abuse. Is that right?
yes, and so I would say that the protections that he sets out don't take into account this risk and don't protect against that risk.
But it's not a protection. He's listing protections in this paragraph, and you may or may not agree with them, and you've already made a point about number 6. But he's saying that these are somewhat protective against the risk that he has found. So I'm not just understanding at the moment where this fits into the question of how likely is it that the father will come back, the mother's mental health will deteriorate, and the children will be back in the position that they were when you had to step in and protect them. That's what the judge is thinking about with the recurrence.
Perhaps, my lord, I'll finish the point on recurrence then, and I'll come back to these later.
Right.
So the 4th point, my lord.
4th.
Number 4
Yeah.
Is the risk of mental health relapse, and I'll deal with this briefly. The judge notes in his judgment that the mother has had a period of settled mental health, and that's accepted. And it's absolutely to her credit that she was doing well. She'd had a year without relapse. She was engaging with her mental health team. She was on medication, and that was deemed to be a positive marker for future stability. What isn't engaged with, and this section, sorry, my lords, is the paragraph 34 onwards, so that's page 65, which is my conclusions with regards to the first responders' mental health. So paragraph 36, he deals with the matters that I've just set out. But firstly, there's no mention of the psychiatric evidence that the court had before it. There was no oral evidence heard from the psychiatrist. But what isn't mentioned is the history. For example, within the recent history, there has previously been a period of a year between periods of very serious mental ill health. The mother has, in the past, tried medication and come off that medication. And she has previously had some engagement with therapy. I believe that she was discharged from talking therapies at one point in 2024 due to a lack of engagement. What the Guardian...
Paragraph 24. Is that what you were saying? Sorry, I may have misheard you, but this paragraph 24 is a historic
paragraph
in which the judge deals with the mother's difficulties in this regard.
Yes. So he references there the fact that there was a hospital admission in 2024 and then an admission in March 2025. I actually think that that's not right, and I don't think it was July 2024. I think it was February 2024. I stand to be corrected.
Yes. As paragraph 21, he deals, albeit in an abbreviated way, with the history, doesn't he?
Yes, that's right. And I don't say that he doesn't address the history at all. I say when it comes to his analysis of the risk for the future, he doesn't look to that history which he has cited, and that doesn't appear in that analysis.
What's the conclusion? Because I mean, we would have to find, wouldn't we, that the judge misunderstood the mother's mental health history and was therefore not taking into account the risk of recurrence. But are you suggesting that he was bound to treat this as being something that was definitely going to happen, or was it just simply something that was a risk for the future?
No, of course, just a risk for the future, my lord.
And do you say he didn't treat it in that way?
I don't say that he didn't treat it in that way. I absolutely recognise that he treated it as a risk that was still there, but it's about his examination of that risk and what was taken into account when looking at it.
But a lot of children, I mean, there are many parents who suffer from weakness in mental health, and a lot of children who have to be looked after by others when a parent is having an episode. I mean, even if, for example, you thought that this was twice as likely to happen as the judge, where does that take us?
It, in my submission, just adds to the overall assessment of risk of things going wrong in the future.
Right. And so what is the objectionable conclusion, as it were, that you were starting further down the judgment in relation to the judge's assessment of mother's mental health?
Yes, my lord. So it's addressed there, and then in the references that appear later in the judgment, there are references to essentially sort of more stability. That then appears to be the conclusion, that whilst there's obviously it can't be said that there's no risk in the future, that the various mitigating factors that now arise contribute to an overall positive indication, if that's the way I can put it. And this part of the analysis is the only part where he actually discusses how he reaches that conclusion, and I say that it's missing that part.
And just to be clear, there are at least two possibilities here. One is it simply wasn't possible for the judge to reach the conclusion he reached. Another is, well, he hasn't explained fully how he reached his conclusion. Can you really say that it wasn't open to him to reach this conclusion?
No, my lord, I don't think I can say that. It's more the latter point, I would say.
And what, again, if you wouldn't mind, just saying precisely what it is that you say he did not take into account, or he didn't explain.
The history of mental ill health and how that factored into the assessment of risk in the future.
He tended in paragraph 91 to see protection from further abuse as being a very strong factor in the
Yes.
maintenance of the mother's mental health.
Yes.
As he said that he considered that supported by sister and in stable housing, she's likely to retain settled mental health and provide good enough parenting. So is that the target of your submission, essentially, in the end?
Yes.
So what is your alternative formulation? What do you, because we would have to be satisfied the judge was if it's just a reasons argument, as I think you've said to Lord Justice Newey, I understand what you're saying about it, but you're not saying that the judge was obliged to reach a different conclusion to the one that he did reach at 91.
I wouldn't say that he was obliged to reach a different conclusion, my lord. No, I think certainly the mother's ongoing vulnerability, and certainly the short period of time of stability that had been observed was a factor that was concerning to the local authority at the final hearing, and it was concerning to the Guardian as well. Both the local authority and the Guardian mentioned it in their final evidence, and that is where it takes it.
Yes, I mean, all of this comes back to the same thing, doesn't it? It's a question of what level of risk
Yes.
is acceptable.
Yes.
And the judge took a view about that. But isn't that really the difference, that you took a different view about it? I mean, I'm not sure how much risk was acceptable from your point of view.
My lord, that I think is probably what it boils down to. Yes, is that in the local authorities case, that taking into account all of these different factors, that the judge's assessment of risk was too optimistic, and that was not a view that the local authority shared, and that the local authority's view was that taking all of this into account, that the risk remained too high and that it wasn't a safe placement.
Well, for my part, I can fully understand the local authority having that concern. It clearly is a concern. But you've agreed that you're not saying it wasn't open to the judge to disagree and to come to the conclusion he did. So Is that right? That's what you said to me.
Well, I think yes, my lord, in that it is an assessment of risk that any tribunal would need to make on that point, as the professionals had assessed the risk, the judge had assessed the risk, and what we say is that in his assessment of risk he erred, but not that it wouldn't be open to him to assess it.
No. And your real problem is, as you said to Lord Alderson Newey a moment ago, is the way in which his failure to address material elements in your assessment of risk.
Yes.
In his judgment.
Yes.
But they were all there in the professional evidence before him.
Yes, they were.
This is a case of very full professional evidence.
Yes.
And the local authority had the opportunity to bring all that together in its case. We can presume that it did.
Yes.
And this judge, experienced as he is in this area of the law, are you saying he didn't take it into account? You're not saying that. You're saying well, there's no evidence that he did. Some of the points are not mentioned in the judgment.
Yes.
It comes down to that.
That's it, my lord.
Yeah. And of course, you know that's a difficult submission in this court, because we don't expect judgments to contain every single point.
No, my lord, and I do absolutely acknowledge that. What we say is that the gaps in this judgment take it further than that, and that it arrives at the point where the court does not know, in some instances, what the judge's thinking was, and cannot glean, and that the overall balancing exercise that took place following that risk assessment was therefore affected by it. That's what we say.
Yes. So that's point 4, is it?
That's
mental health.
The fifth point is somewhat different, and I only address briefly, my lord, and that's on the point of immigration status.
Yes. Whose immigration status?
So the children, the youngest child in particular, and the mother's immigration status. So the middle child
Is
has
British citizen.
has British citizenship.
Yes, because of we've read about why that happened.
Yes. The mother does not have settled status in this country. She has a pending application for leave to remain, which we understand isn't indefinite.
Has she got what she got at the moment? I'm sorry, I haven't tweeted this. What form of leave of remain has she got?
It's a visa of limited leave to remain.
Thank you. Limited leave to remain. So she's applying for indefinite, is she?
I think
with
she's
a view
at
to
the stage before
settled
that.
status, isn't it?
She's at the stage before I understand that she can apply for indefinite leave to remain, and she can apply for the 10-year limited
right.
leave now.
Yes.
So sorry, the current limited leave to remain is for what period?
Is it for 3 years?
3 years.
Is it 3 years? Two and a half years? It was 3 years, I think.
It's 3 years. It is 3 years.
I think it is 3 years.
3 years from...
3 years from when it was granted.
And when was it granted?
Well, she arrived in 2019.
Yes. 2019. It's expiring. She arrived in 2019. That 3-year period has expired, and the renewed application is still pending, and it had been made by the mother before the proceedings started.
So it was an in-time application.
So she's hanging over in whatever way it's called.
Yes. Right, so where does this fit into the...
So there's also the fact that obviously the eldest child who doesn't form part of this appeal, but also the youngest child also do not have leave to remain here, and they also, I understand, are the subject of ongoing applications.
Yes.
So I raise this just to say that this is a real concern of the local authority, that this hasn't been regularised. It hadn't been regularised during the proceedings, and it didn't factor into any of this analysis that this is a potentially unstable placement, and that...
So what's going to be done about it?
Well, at the moment we don't have parental responsibility. We know that the application is pending. During the proceedings we had asked for an update from the immigration solicitors, but I understand that we weren't provided with that update. At the moment, I don't see that there's much that
How
we
does
can
this
do.
impact upon your appeal?
Well, we say that was one of the reasons why we're concerned about this placement.
So you say there's a question mark over the mother's future ability to remain
Yes.
in this country, and so how does that affect the decision for the children?
Ultimately, if the children were, it potentially means that the children's ability to stay in this country is unstable as well, and it just affects the stability of the placement generally.
Was that a factor which the judge ought to have taken into consideration in deciding whether to grant a placement order? There are thousands of children in that position.
Yeah.
You see lots of cases wearing our immigration appeal hat, in which children are in that position. Is it? I mean, obviously, they're not usually subject to care proceedings. But is it your case that this factor was a factor which the judge ought to have weighed in the balance in deciding whether to make a placement order in respect of these two children, or rather, just the one child to whom it applied?
Yes, just the one child.
Separating the child from the sibling.
My lord, I do think it is relevant. Obviously, the family court can't sort of hang on the outcome of any sort of immigration decision, but when it comes to permanence for the children, I would suggest that is relevant consideration
Where
for the
is
child.
To the one
Where
child.
is it in the papers that we've been given?
It's the issues of immigration.
Yes, I mean, of course, there's a mention of the fact that they don't have settled status, but is there any reference at all within your case that one of the reasons we should have a placement order is because their status in this country is not secure?
My lord, I don't have a page reference for you. I certainly, my understanding is, and if I might just highlight, that it was raised at the Parliament.
It is mentioned.
Yes, it is. Well, that it's a reason for a placement order.
It's just part of the inadequacy.
My lord, so my understanding is that this feeds into a concern that there could be a return to Grenada.
There could be.
A return to Grenada, and that would bring with it risk. But I am not told that this was raised at the final hearing.
But was that a feature of the evidence before the judge? Because you ought to be able to show us where this surfaces if it was a feature of the evidence.
My lord, I'm in that invidious position of feeling like I've seen something but not having a paragraph.
I think we've all got that feeling.
To be really unfair,
I really...
is it in the original compendious 10 grounds of appeal?
No, it isn't. It isn't, and to be fair, I don't think it's in the skeleton argument either.
Okay. Well, I quite see why you raise it, because it's one of the imponderables
Yes.
in the situation. But I mean, I think you'll understand, and you haven't said anything to the contrary, that you can't have foreign children adopted just in order to deal with issues about uncertainty of immigration.
No.
I mean, indeed, I mean, I don't know whether this ever arose, but normally, if you're seeking a plan for adoption of a foreign child, then you would notify the authorities of that country in order that they could say what they thought about the adoption of their citizens. But I don't know whether that course was followed in this case. I don't see the Canadian authorities as having taken any particular role.
I'm not aware of them being notified. No.
All right. Well, those your 5
They were,
points?
my lord. I think I've already addressed the court on. There are a couple of just sort of wrap up points that I wanted to make, but I think I have addressed most of them. Just quickly to turn to those protections.
Yes, back at paragraph 92.
92, yes.
Yes.
So firstly, the experience of the proceedings. I'm not quite sure what that means. I think it means that having been through the care proceedings, that there's less of a risk of these issues arising in the future. I think that's what that means.
It means, doesn't it, that the proceedings have ventilated all these issues in a way which has crystallised them, and that's a factor. They're out there. They're known about. They've been discussed.
That wasn't how I.
Your facial expression suggests you're not impressed with that analysis.
Certainly, I'm not clear as to exactly what that
well,
means.
we read that as we will.
Independent housing I've already addressed you on. Family support I've already addressed you on. Mental health stability I've addressed you on. Supportive programmes again. I just want to briefly address the court on the focused non-molestation order and the package of suitable contact for the father which will allow safe contact and the sort of planning generally. So the court at this stage hadn't seen a safety plan. The judge makes reference to there being at point 6 a robust safety plan, but then directs the local authority to provide it. So he hadn't seen what that safety plan would look like at that stage.
But presumably there was some evidence about what it might look like. I mean, if you come to court looking for a placement order and a care order, then you have to have a plan for what happens if that plan is not approved.
That's right.
And I'm as sure as I can be, having no information about this at all, that there will have been discussion with the professional witnesses about what will be needed if this is the course that the court takes.
So there was a supervision order support plan that was in the bundle, but in terms of the safety plan, I'm unable to say exactly what the special is.
Where is the
I'm so sorry, my lords. There was apparently a draft safety plan sent in on the first day of the hearing. So
A draft safety plan?
A draft safety plan.
Right. Is that amongst our papers? No. Okay. But the concept of a safety plan is, as it were, it's a generic document which is then adapted to the needs of the individual case.
Yes.
Yeah.
Where's the supervision plan?
No, it's not. There isn't one.
There's no supervision plan?
There was a supervision order support plan. It's not in the core bundle.
Okay.
And the safety plan.
And a safety plan.
I hadn't seen this draft safety plan.
Right.
Sorry, my lord, if I might just. Right, I'm told it's not in the bundle. It was apparently sent around during the final hearing, but
Right.
I've not seen it.
All right.
Do people do? It's some years since I looked at this element, but the Schedule 3 has provisions about what can and can't be attached to a supervision order, doesn't it? I'm not clear whether that's used very much. I can't remember where the case. The red book suggests the cases were all a long time ago, when I was still in practice. But there's nothing. So there wasn't any attempt to add a sort of condition or direction, direction under Schedule 3.
No, I don't think so.
Okay.
All right.
There's a plan, but nothing specific.
Exactly, my lord, and that's certainly my reading of this final part of the judgment. Is there needs to be a plan, but it needs to be drawn up,
Yes.
and there are no specifics about it. Then
Oh, sorry. Is that a criticism of the judge?
Well, it's more of a query, my lord.
Well, I'm sorry.
But yes, no, it is.
That's
no,
not.
It's
I mean, is it or isn't it a
It
criticism
is.
of the judge? I mean, if you're given a supervision order, you're going to have a plan.
That's right. What I would suggest is that what is being said here is that there needs to be various different plans and orders that are put in place which form part of this protective scaffold, and that the judge hadn't seen what that would look like.
But you put a draft forward, forgive me for interrupting, drafts of it. It's not uncommon for the judge to say this in the judgment before everything's being crystallised.
Yes.
Isn't that? It happens all the time.
That's right, and certainly if it turns out that a draft plan was sent, then that submission loses some force.
But also,
So
you had some days before this judgment was handed down in order to get this in order. That was the time, rather than now. But anyhow, we've now got the non-molestation order.
The non-molestation order. So the only thing I want to say about that is, so that's for 2 years, running alongside the supervision order no longer. That non-molestation order is in the bundle somewhere.
Yes. Page 50, 57, 998. Tab 8. Yes.
Yes, thank you, my lord. So that focused on molestation order prevents any communication at all by any means, and visiting at all. At the same time, the judge says that he doesn't want the mother to be the person who is managing contact. But it's not clear to me exactly what is envisaged in terms of how that non-molestation order is going to be effective. What if there are breaches of it? What if there is contact? What's going to happen under, what mitigating measures are going to be put in place if anything does go wrong, that it stops at that point.
But what is the local authority case? That the children should never see their father again?
No, my lord, certainly not that.
So it's got to be managed.
Yes, it's got to be managed.
It's got to be managed wherever they're going to be for the foreseeable future.
Yes. I think my point there is simply that this required more detail and careful.
Right, okay, that's the point on the enemy.
Other than that, my lord, you have in... I've already addressed your lordships on the fact that essentially what all of this boils down to is that the risk assessment was deficient, and therefore when it came time to look at the options in the balancing exercise, that balance was off kilter. The other side of that balancing exercise was obviously in my submission the delay point for the Canada placement, that there is a real weight given to that delay, and of course it's understandable that the judge would be concerned about such significant delay in these children's timescales, especially when they're so young. But essentially we say that's where the analysis went wrong, in that what it should have been weighed against is the much more significant risks and significant risk to safety. That's what we're saying.
So you weren't looking for what is described as stranger adoption?
No.
No. Your case was Canada?
Canada, yeah.
Right.
Why did you need a placement order? The placement orders only apply to placements over which the local authority has power or jurisdiction. Placement abroad doesn't come under the placement order.
So the reason for this was that the parties had some immigration advice, I understand, that essentially said that whilst, for example, the children could be placed under a special guardianship order and go to Canada that way, that there would be ultimate consequences for their immigration statuses in Canada, and that that they would essentially be coming in as a visitor to Canada. And so the way to achieve stability for them in their ultimate placement would be for it to be an adoption.
Here
And in Canada.
Okay.
The significant time frame.
Paragraph 51.
Yes.
Right. So the judge had two realistic options. One was the one that he selected, which was supervision order with a return home, and the other was a combined timeline agreed of 2 to 3 years before permanency in Canada, if that could be achieved.
That's right, my lord. And the crucial point there is that it would be a timeline of 2 to 3 years for permanency. It wouldn't be, for example, that would be the point at which they could first go to Canada. That would be the point at which their immigration status would all be sorted out at the Canadian end. And that's, I think, agreed in that paragraph. That it's the
Well, 6 to 8 months towards a positive outcome, but it may or may not be positive.
Yeah.
Then 1 or 2 years to resolve immigration status. And then a family placement.
Yeah.
And are the parents to play any part in the children's lives?
Yes, my lord. That was the major advantage that was seen of the Canadian option, was that it
Because
was...
what, they can freely pass in and out of Canada?
I'm afraid I don't know that.
And what happens to the 14-year-old
That
who doesn't want to go to Canada?
No. The 14-year-old does not want to go to Canada, and they don't have room for her in any event, the Canadian relatives. So that was never an option.
I mean, in a sense, we don't need to go on with this, but those were the two options.
Yes.
Paragraph 51 or what the judge decided.
Yes.
And paragraph 52 is the judge accepts the guardian's proposed approach. Would you ever consider the placement of the mother? Is obviously you have to consider the placement of the mother first before any final decision about placement in Canada.
All right.
Just finally then, my lords, just on the point of legal principles, very briefly. I don't propose to spend much time on this issue, just to say that whilst, of course, there's no necessarily no obligation to sort of cite specific cases if the judge is taking the relevant principles into account, I would say that not all of the relevant principles have been taken into account, but the vast majority of them, I say, have.
Did the judge have an agreed note of the law?
No, I don't think so.
Well, can we short circuit this? What significant legal principle is not taken into account in this judgment?
It's just the no order principle, as far as I can tell.
But,
So,
well, who's suggesting no order? I mean, that was
No,
firmly ruled out, at least by the Guardian, and
It was.
presumably by any other professional.
yes, my lord, this is why I don't propose to. I just raise it as it's not dealt with in the legal principles section. So,
Well, so there isn't one of those interminable boilerplate sections of the judgment in which things that everybody knows are repeatedly set out to no good purpose. Is that it?
That's it, my lord. Yes. My lord, you have the cases that were set out in skeleton argument. I don't propose to refer the court to them in any great detail unless it would assist.
No, well, unless there's any further distinct point you want to make to us, I think we've got a good view of your submissions, both individually and as a package.
Thank you, my lord.
Anything else, Claire? What I'd like to ask you about is just this. If the appeal does not succeed, then what are the next steps for these small children? What has happened, if anything, so far, or has it effectively been frozen since the appeal was in prospect?
So they are having contact with their mother, but there has been a delay in the transition plan of 3 weeks. So,
Right, so we're 3 weeks behind
3
what
weeks
would
behind.
otherwise have been the case, is your understanding?
yes, so they haven't yet progressed to unsupervised and overnight contact. Is that right?
Well, if I may say so, I wouldn't wish to be at all critical of that without having heard from the other side, because in a sense you don't want to start something and then have to go back if the appeal was to succeed. But what stage have we reached then? That they had been having twice weekly contact in the contact centre,
Yes, that's right.
and what has happened to change that since the judge?
So it's the eldest child going back home last week.
Yes.
And there is also, I think, a trip to Centre Parks, which is...
So it's moved outside, modestly outside the contact centre.
Yes. Sorry, my lord. Yes, so those are the two factors that have caused delay, is the eldest child going home to her mother, and there were... Essentially, we wanted to make sure that that was really stable.
Yeah.
And then secondly, yes, I think there's...
Was the idea it would be a sequential
Yes.
process.
But I think there is a possibility of certainly a slightly expedited journey towards overnight.
Right. Well, clearly that's a matter that is best discussed by people who know the children and know the practicalities. And it's also at the moment, obviously, we need to hear further arguments. But in a nutshell, leaving aside compression of timescales and so forth, it was a plan that was going to lead to some overnight contact, and then a date would be fixed for a return home.
Yes.
No doubt a lot of oversight and so forth in the earlier stages,
Yes.
to see that what was going to be needed. And what sort of bracket is that taking place in? What's the rough envelope for all that happening in time terms?
As in to a move-in date from now?
Yes, I mean, what are we talking about?
Well, it was going to be 4 months overall, wasn't it? I'm afraid my maths is not good enough.
Well, I think it, yes.
In advance of the end of the school year is when we would want to have him back with the mother.
Right, so we have one child still at nursery and one child in school.
Yeah.
Right, and so it's a sort of before the summer holidays.
Yes.
By the summer holidays, the sort of thinking, if that is the way it goes.
Before the summer holidays, we would like that transition to have happened when they're still at school.
There's a lot of planning that would be needed. Okay, that's very helpful, just as to make us understand what you're thinking, if that's the outcome.
I'm grateful. Thank you.
All right. Thank you very much indeed, Ms. Miller. Yes, now, could we, I think what we'd like to do is to hear the headlines from each of you. Of course, if there's any illustrative detail that you think is of particular interest to us, then please give it. But rather than setting off on full submissions, could we have abbreviated submissions from you all, please? And as it's a rolled up hearing, we'll then see where we think we ought to go. Yes, Miss Muse.
Thank you, my lords. My lords, if I may start with the ultra-vires supervision order. Of course, it's accepted that that was unlawful. It should have been brought to the judge's attention. I'm at fault in part for not doing that. Certainly what was in my mind and what was in the judge's mind is the possibility of extending the supervision order for another 12 months once a 12-month order has expired. My lord, you've heard that the older child, Jay, has returned home. I'm told that there have been no problems with that.
Well, I don't think we want to, as it were. I think we'll just not know about what's been happening there because there's no appeal in her case.
Very well. My lord, then, if I may start with the complaint that there was a lack of reference to the legal principles. My headline point on that submission is that it is apparent throughout the judgment that the judge had in his mind and at the forefront of his mind the essential legal principles. So the RE-B principle, the need to carry out a global assessment of the competing options, the need to carry out an assessment of risk based on findings, to consider what matters could be put in place to ameliorate risk, and then to look at what could be done when having regard to the welfare checklist and the children's best interests. Clearly the judge, we say, had that in mind throughout the judgment and those legal principles in his mind throughout the judgment. And the need to consider, when looking at the risk, whether the local authority's proposal was proportionate to the identified risks.
Right.
And she clearly said no, adoption was not a proportionate outcome to the risks that he had identified and analysed. My Lord, in relation to the domestic abuse allegations broadly and the submission around work that should have been implemented, the local authority at the IRH in November specifically said they did not seek a domestic abuse, a DV Act risk assessment.
Well, this is it's a DV Act. Is that an organisation, a commercial organisation? Right, it's called DV Act. I confess I haven't come across them, but so that's at the IRH in November 2025. The DV Act assessment was not pursued.
Correct.
Right, because it was it was an issue which would impact on timetable.
Correct.
Right.
And that was the local authority's position. My Lord, nobody at the hearing doubted that Mother had engaged in the work, the Freedom Project work, and was genuine in her reflection. The issue was, would she reunite with Father at some point? And my Lord, the issues in relation to the separations and the reconciliations, we say, have been dealt with in Mother's two statements. I refer to those two statements where she deals extensively with why it was she says that she had reconciled and
So I'm sorry, I'm losing what you're saying. That we've got two statements from the mother. Do you want to take us to any particular passages in any of them to make this point?
yes, my Lord, please. So it's my page 170 of the bundle. It's paragraph 9 of her second statement, which was the 31st of October. So in a paper bundle, that would be at 170. So paragraph 9 to 13 of her second statement.
Sorry, that's an account of assaults. If I'm in the same
Yes.
place.
And paragraph page 216 to 217 of her final statement. So paragraph 5 to paragraph 9, which my Lords will find at 216 to 217 in the paper bundle. And she talks about why it was that she had reconciled and retracted her allegations.
Right, so her case was separation in October by that
Yes.
stage, right?
And crucially, at that point, she had engaged in domestic violence work. She had not engaged in any domestic violence work prior to the work that commenced in September, and she very clearly states that having embarked on that work, she reached an understanding of what domestic abuse was, and my Lords, the learned judge found that he believed her and that her reflection was genuine. My Lords, in relation to the concerns raised by the psychiatrist and the independent social worker, I remind you that those assessments took place in July of 2025, at a time when the parents were together, at a time when the parents were asking for the children to be returned jointly to them, and no further work had been undertaken by the ISW post the parent separation. So her concerns at that point were in a very different context, we say. And as I've just outlined, mother undertook the work that was part
Yes.
of the work that was recommended. My lords, in terms of mental health, the consultant psychiatrist detailed, and I won't take my lords through every detail, but in my explanation argument, mother's very good compliance, mother's very good insight into her mental health, and he confirmed that he had no reason to believe that she would not continue to be compliant with her care and treatment plan.
This is the psychiatrist.
The psychiatrist. So it's Dr. O, and it appears in his assessment at page 89, paragraph 3.13, 3.15, 3.16, 1.7, 1.
Yes, just pause a moment.
119, etc.
You're reading from page 89 and around there.
89 to 90, my lords, yes.
So the passages that the judge was relying on appear at the turn of the page between 89 and 90.
My lords. So the professional evidence in terms of her mental health, we say, was very optimistic. Even in July, the concern was, would she reconcile with father?
Yes.
My lords, and the judge does deal with this in his judgment. One of the concerns was previous appalling housing and how that had impacted on the mother's mental health. I've dealt with that in my document. It is not surprising that those appalling conditions impacted on her mental health.
Right.
And the judge has clearly dealt with the change in circumstances, the stable housing being a protective factor in terms of her mental health, and that in turn being a protective factor in relation to her ability to stand up to the coercive, controlling,
Right.
difficult.
Well, shall we stay with the headlines for the moment?
Father. My lords, I think I hopefully have dealt with the domestic abuse,
Yes.
the mental health, the important and the crucial matter of the analysis, the risk assessment, and the proportionality assessment, which we say were at the forefront of the judge's mind, very evident throughout the judgment. My lords, those are the headlines.
Thank you. Very helpful indeed. Thank you, Ms. Lewis. Yes, Mr. Mills.
I will also try and stick with the headlines. First of all, I, like my own friend for the mother, have to accept that I was there at the hearing and I didn't spot the 2 year supervision order points.
It's very easy with hindsight, and I mean, I'm taking it from what Mr. Muse said, that she made an internal calculation of 1 + 1 rather than 2, but it is unfortunate that it wasn't, this aspect of the matter at least wasn't dealt with at the time, because judges are entitled to expect help from counsel because they have quite a lot on their shoulders. There we are. It is where we are.
Well,
and
it will certainly stick with me going forward. But there we are.
right, so
AI wouldn't have made that
Yes,
mistake.
no.
You've got to be careful.
Let me just firstly briefly address the two main points made in respect to the appeal. So firstly, the supervision order and adequacy of reasons. In respect to the supervision order, I just point to the judge at first instance's response to how that's being dealt with
Yes.
going forward. I say no more on that point, in that in headline form, it wouldn't have made a difference to the outcome of these
well,
proceedings.
the residue from that point is whether it feeds into the list of general points made by the local authority, which is that it led to the judge getting the balance of risk wrong when making his welfare assessment. So we have that well in mind, and we don't need to particularly ask you about that, but could we stay with the technical side of this for the moment? That we have a judge who's made an order which is outside his jurisdiction. It's got made, unfortunately, and then when he realises it, he's immediately corrected it. And we get another order, so we've got two orders which say different things. Is there anything that you'd like to offer in relation to how it might have been done differently, or secondly, now that we've got two orders that say different things, what needs to be done now?
I wasn't privy to what went on in the interim between the first order being made and the second order being made, but in terms of what needs to be done now, we know that it needs to be a 1-year supervision order. We actually have an order that sets out exactly what needs to happen for this order to be made until March 2027. So we just need to make sure that those orders show that going forward.
But what hasn't happened, apparently, is that the judge didn't, as part of his housekeeping exercise, and I understand that he's the lead judge for this area, and he has many things to deal with, but it would seem to be right that he ought to, at the same time, to have corrected the first order if he considered that he had the power to do so. So the query, so that there weren't two orders that said different things. And at that point, the question arises, did he have the power to correct his first order on the basis that it was effectively a slip, and a power that's preserved under the rules? Is this a slip, or is it something that is beyond that?
Well, without going into the technicalities under the slip rule, my submission would be that we have that very succinct response from this judge, that my submission says that it would make no difference to the judgment.
No, that's not the point I'm asking you about. I'm asking, we're faced here with an application for permission to appeal, which we've not yet determined. And at the time that that application is coming before us, we have two inconsistent orders. And so the question is whether that matters. And if it does matter, what do we, if it doesn't, why? Doesn't it matter? If it does, what do we do about it?
It doesn't matter in my submission. And that is because we know that the reasoning behind that judgment is fully set out in the 99 paragraphs that we have. The court's very aware of the case of Reby and the different factors that are set out in that judgment as to what needs to be dealt with in every judgment that the court sees up and down the country. In particular, I emphasise the point about, quote, key features of written and oral evidence, bearing in mind that a judgment is not a summing up in which every possibly relevant...
I'm sorry to interrupt you, but I think we're straying into a point that is, at least in my mind, different. I understand what you're going to say about the presentation that we've had from the local authority as falling into a category of asking for too much from the judge. I understand that point, but at the moment, if you don't want to make a submission about it, I don't press you. But we do have to deal with the fact that we've got two inconsistent orders at the moment, and that has to be cleared up one way or another. We know what the judge wanted to do, as he's told us. He wants a 1-year supervision order.
Do we need to set aside paragraph 9 of the first order?
Yes, but I've mentioned the slip rule's been mentioned, and I wouldn't want to make submissions on that without...
All right, well, if you don't want to make submissions about that, we've grasped what our problem is. So
I'm not sure we could use the slip rule.
no, we can't. No.
That's my concern.
Well, the only way of dealing with it would be by either allowing the appeal and changing the order for that purpose, or for doing the same as we did first time, which is say to the judge, what do you want to do about that order? Because there's an obvious answer, which he's going to set it aside if he has the power to do so, but we need to decide whether he does.
Yes.
Sorry.
You can see my hesitance
I
about
think that's the parameters of what we have to deal with.
Yes.
Yeah, all right. Right, what
Yeah.
other matters?
Well, in terms of where I was up to, I was emphasising that part of Reby, and it's already been mentioned by my lord, in that it's about putting the points in that are seen as relevant by that particular judge, having seen the evidence at the time. This was a 4-day rolled-up hearing. It had 3 live allegations in the schedule of allegations sought by the local authority, put with the 1 allegation that had been admitted. it had the independent social worker who was giving evidence as best she could following the report being dated 30th of July 2025, parents separating in October 2025, and then the father leaving the jurisdiction in December 2025. So a number of significant developments since her involvement with the case. The allocated social worker, the mother, the father, and the guardian. Paragraph 90 onwards in the judge's judgment expressly states how he disagrees with the professionals that I've just mentioned. That is dealt with in my submission. In relation to the mother's mental health, that wasn't a particular concern at the time of the hearing. We've heard about how well she was doing at this time, and the psychiatrist not being called to give evidence on the optimistic prognosis that the mother had been given in this case. And we also have that, quoting the judge's judgment, bi-directional involvement of domestic abuse that had been found by the court by the time in this judgment, and the mother's mental health. So if I can deal with the 5 points briefly put forward by my learned friend for the local authority. In relation to retraction of allegations, point 1. The judge has dealt with domestic abuse as a whole, as well as looking at the particular allegations that were to be determined at this hearing. I appreciate my learned friend's points about the third allegation remaining disputed. But the evidence of the father actually coercing the mother, as has been set out in this judgment, was particularly weak. The cross-examination didn't bring out a number of these points which perhaps the judge would have wanted. And in any event, by the time of this hearing, the parents have separated since October 2025. And at this point, the mother was actually supporting these allegations being found on behalf of the local authority. And in any event, as the court's already pointed out, this clarification point wasn't raised at the time when judgment was handed down. Point 2, in relation to the overall seriousness of the domestic abuse. The point about paragraph 6 of the schedule wasn't actually pursued, well, wasn't allowed to be pursued by this judge, because we were still left with only those 3 points of the schedule going forward. My recollection is that it was going to be taken into account more from the welfare element of this case, rather than an actual finding in relation to coercive controlling behaviour. The strangulation incident, it's said by the judge that the cross-examination didn't allow for further findings to be found or further clarification to be found. Well, that's of course the local authority's advocate to do that cross-examination, to bring those points out from the father. And indeed, when it came to an opportunity for the advocate for the local authority to cross-examine the mother in this case, who all parties were, to be clear, working under the advocate's toolkit for vulnerable witnesses. And so it's not for me, on behalf of the father, to try and cross-examine to clarify the points that haven't come out on behalf of the mother's evidence. In relation to so then, in terms of the overall seriousness of the domestic abuse, it is not surprising that the judge found the strangulation instance not be perhaps as high as the local authority had put it in their schedule. Just one moment, if I may. Point 3, risk of domestic abuse arising again. It was the mother's application to have this DV Act assessment, looking at the dynamics of the parents and how that could be mitigated perhaps going forward. And so it wasn't for the local authority, it wasn't the local authority who initially wanted to have that application. And so for them to now say that that's a bar to the children going back just isn't fair on the parents in this matter. The point about the father being willing to engage in domestic abuse programs now, I appreciate it might have been a shift from how he had presented when he was in the jurisdiction. He's out of the jurisdiction by the time of this hearing. He remains out of the jurisdiction. I put in cross-examination to the expert witnesses how, of course, he would need to go and find that help that had been recommended to him himself in Grenada, because this local authority couldn't help with that. But again, I don't see how that should be held against the parents in this matter. If anything, the father being out of the jurisdiction improves the prospects of the children being able to be safely reunified into the mother's care. The local authority pursued the non-molestation order in respect of the domestic abuse allegations that were found. It wasn't opposed by the father, but it was opposed by me from a legal perspective, given that he was out of the jurisdiction. And so this point made now as to the enforceability of the non-molestation order that the local authority actually sought doesn't seem to make any sense. It cannot be held against him that he's left the jurisdiction. That's perfectly within his right to do so.
Right.
And finally, to say the separation was recent, it wouldn't be correct for, or I doubt any sort of adjournment application would be given particular, it wouldn't be received particularly well if we were going to say we have to wait X amount of time for a separation to take place before we know that it's not going to reoccur or have further issues. Point 4, mental health relapse. Again, highly significant the father's out of the jurisdiction because of that interplay between him and the mental health issues, which is found by the court in this judgment and set out clearly in this judgment. And in any event, the psychiatric expert's not called in this case, so the positive, optimistic prognosis there is unchallenged. Fifthly, finally, point 5 on immigration status. It wasn't mentioned at the final hearing. I'm sure the court will take that no further. My recollection is there was no safety plan circulated. I've had a quick look at my emails. I'll have a look again and maybe
Can you
correct
tell
it.
us when the draft judgment was received?
15th of March. It was Sunday, 15th of March.
Yes.
And
The parties had that document for the whole of the working week before the judge handed it down.
correct. More to clarify.
As a matter of interest, were there any typos, editorials, corrections, or did the draft judgment reflect the final judgment?
I will try and find it, but I can recall a couple of grammatical things, nothing particularly major.
That's all.
Just finally, if I may assist, it may be of assistance to know that the immigration advice regarding Canada was actually received within the final hearing itself, which did cause some difficulties. And finally, it was put by my learned friend for the local authority that the legal principle of no order principle hadn't been mentioned. The court didn't make much of it, but actually, if we look at paragraph 13(1)(3) of that judgment,
It's in there.
it's quote, this does not mean that I must make the order sought. You can see what that means in reality. But those are the headlines, if I can assist any further.
Very helpful. Thank you, Mr. Mercer. Yes, if it isn't inconvenient to the parties and court staff, then we'll, if we may hear you, Miss Watson, now, so that we have everything in mind as we come to it.
Yes, thank you, my lord.
The end of the morning.
I'll try to be brief and focus on headlines. I'm afraid I can't assist the court in relation to what appears to be the collective amnesia that afflicted the lawyers in this case in relation to the clearly wrong order made by the court of a 2-year supervision order.
Well, you can, if you want to assist us as to what gets done now about it, then please do.
Well, my lord, now, my lord, I say that the court should that should be the appeal should be allowed insofar as it relates to that part of the case, and the court should substitute a 1-year supervision order for that.
Well, we don't have to.
I'm sorry.
We don't have to. There is a 1-year supervision order.
Just delete it.
This is the. This is the.
Well, my lord, yes, indeed.
Right. Anyhow, okay.
At the time, my lord, clearly, and not really even with the benefit of hindsight, had the learned judge been alerted to the error that he made, he could have invited.
Yes, that's why allowing the appeal on that basis seems like rather a sledgehammer approach.
I appreciate that. I mean, the learned judge has been receptive to the request of the court in relation to
Well, what we've had is
clarification of his
we've had sort of
decision.
misfortune on misfortune, namely that when the judge was asked to deal with this point, he dealt with it, but he didn't deal with it completely,
No.
and nobody asked him to do so.
No. My Lord, I would submit that, of course, under Practice Direction 29, the slip rule, the court can be asked to correct errors and omissions in judgments and orders. So that potentially would have been a mechanism available to the learned judge. He could have set aside that order and replaced it with the 1-year supervision order, which, alert to the fact that he'd made an order he couldn't make, would have mirrored or would have reflected what he intended to do, which was clearly to create a situation in which the younger children were returned to the care of the mother with support, because he had identified, having heard all the evidence in the case, that she could provide good enough care with support. That was a fundamental part of the exercise that he was undertaking.
So you're saying he really, in effect, did correct it under the slip rule, is that what you're saying? Although he didn't actually do it in terms of amending the order, the consequence of making the second order.
Well, it has been corrected.
Is that he superseded paragraph 9 of the first?
It has been corrected.
What's so odd there is we're told that the second order was uploaded before the judge was alerted to this problem.
Yes, and that may be...
So somehow or other the order was already made before the judge knew about it.
Well, whether it's, as my Lord Justice Baker has observed, simply a function of the way orders are drawn up, it's been corrected.
Well, one of the things that happens is that judges are informed when an appellant's notice is filed that there has been an appeal, and the appellant's notice in this case is dated the 25th of March, and so it's not impossible that the judge came to hear about this appeal as a result of the appellant's notice rather than about by order. And so it may be that his note, I mean, I'm here, this is speculation, but I'm here thinking that he might have then given his reasons for what he had done rather than for what he was about to do or was doing at the time that he gave the reasons.
My Lord, just to touch briefly on a matter that was discussed earlier, of course, the learned judge could have invited, had he wanted to, some short submissions in writing on the legal framework, given that he'd made an error, an order that was
I'm sorry,
wrong.
I'm not hearing you.
The learned judge could have invited submissions in writing, short submissions in writing, on the legal framework, having been alerted to the fact that he'd made an order that was not that he was not permitted to do, and that
Just about what was the extent of his powers to put it right?
Well,
that's the issue that he might have asked about.
Yes, indeed, and that might have teased out, for example, some submissions on why a care order might have been a preferable framework to try to achieve what he wanted to achieve. But, my Lord, taking the approach that this very experienced judge did, he was looking at proportionality, and he concluded that having determined that this mother could provide good enough care with support, that the appropriate legal framework was a supervision order. And that's an order that's made, as my only friend has just observed, up and down the country, and routinely, implicit or explicit, is the notion that support will continue to be provided, whether it's under an extension of a supervision order or through child in need provision. So there was nothing exceptional about what the judge had decided was in the best interest for these children. The issue was he made an order that he wasn't empowered to make. And my Lord, the fact that he made that order, which he wasn't empowered to make, we say it was not fatal to his ultimate welfare determination. And in short, my Lord, the Guardian's position, which I accept that this appeal was different from the position that we take today, in terms, my Lord, the Guardian was clearer in respect of the older child than in respect of the younger two children. Her focus was very much on the possibility of placement in Canada, but she was highly concerned about that timescale. But she had envisaged that through the children looked after process, the mother, as a potential carer for the children, would be looked at through that process, and that work would be undertaken. What the learned judge has done is he has concluded that the mother is able to care for these children with support, and has really concertinaed the process that perhaps the guardian would have wanted in an ideal world, which would have been a combination of some of the work identified by the independent social worker.
But I mean, this case was already approaching
Precisely.
twice its statutory
Yes,
maximum.
it was coming up to a year.
Yes.
I mean, my lord, in reality, none of the realistic options for the children were straightforward. Canada was highly problematic because of the timescale. The home study had not been commissioned. The outcome of that study was, of course, unknown, could have been negative. The immigration status of the children was unresolved. My lord, may I make this observation? I'm bound to say that the point made by the local authority in respect to immigration is, I would suggest, a bad point. These children were the subject of interim care orders for nearly a year, and the local authority was in a position to take steps to regularise their immigration status. And so I suggest it ill behoves the local authority to criticise perhaps the mother or at its highest the judge for not having dealt with that, when really they were in the best position to do so when they held those interim care orders. So, my lord, no straightforward options. Canada, adoption in England and Wales, well, my lord has seen the family finder statement suggested a timescale of 12 to 18 months for placement following the making of a placement order. So again, a really...
It was, I thought that nobody was suggesting that as an option.
My lord, it wasn't advanced, as I understand it, as an alternative, but clearly the local authority was seeking a placement order, and the Guardian's concern was that if the case concluded with a care order, placement order and the Canada route, that if for whatever reason that went wrong...
Well, the court couldn't have approved a care plan and a placement order without knowing whether the local authority's plan was to place them in England or in Canada.
Well,
it would have had to know much more about that.
Well, my lord,
and at the moment, as I understood it, as matters stood, nobody was suggesting that there was a realistic option of adoption by English people.
No, my lord, I have to accept that, but I think it is an illustration of the starkness of the decision for the judge, if you like, that clearly for children of this age, long-term foster care would be and wasn't on the table.
Unless he was prepared to adjourn the case,
yes,
for quite a long time, then he had only two possibilities to choose between.
Yes, and being realistic, there were issues with the mother, clearly. And my lord, the Guardian, her position is she has made her recommendations. They were not accepted by the learned judge. This is a very experienced circuit judge. His judgment is a very thoughtful, we say, and careful analysis of this difficult case that was before him. And we say that throughout the judgment, we can pick up repeatedly references and analysis of the important themes. As he himself says at paragraph, I think it's paragraph 12 of the judgment, well, it's the heading, paragraph 11, electronic 104, page 63. What are the relevant legal principles? He addresses that, the principles fully. Sorry, I just missed my paragraph 7, I apologise, page 62. Electronic 103. What are the real issues in the case? So right from the outset, the learned judge is fully focused on domestic abuse. And that is a theme that runs throughout this judgment, both in the section that addresses the fact-finding. And my lord, I do invite the court to attach weight to the fact that the learned judge was invited on behalf of the father not to conduct a fact-finding exercise in this hearing, and he decided that that exercise was necessary. And we say that it's clear from the judgment how he has approached the exercise. He's applied the relevant legal test, the burden of proof. We can see in those paragraphs where he deals with findings.
Well, I think we're at headline stage at the moment.
Yes, apologies, my lord. So we say there is no realistic basis on which it can be argued that the learned judge has not fully considered the issue of domestic abuse. At the end of the judgment, he identifies that it continues to be a risk factor. My lord, there's I think an important observation that the learned judge makes at paragraph 37, page 66 of the judgment, where he talks about the complex dynamic in relation to domestic abuse, which touches on the point about the failure to weigh properly into the balance, as I understand the local authority to be saying, the retractions made by the mother.
Which paragraph were you taking us to?
Paragraph 37.
Penultimate line.
Page 66.
The comments, yes, I find
Yes,
it.
my lord, I suggest that's an important insight, really, into how the judge viewed what is, I think, understood to be often a very complex and nuanced issue. And I say that his analysis and findings do not stand up to the criticisms that are levelled at them by the local authority. My lord, the mental health issue, again, my lord, the learned judge heard from the mother, and he assessed her as someone who was not just paying lip service to the concerns of the professionals. He explicitly refers to that. In terms of her overall credibility, he assesses her to be open and having been honest. And he was uniquely placed, hearing this mother, presumably cross-examined, about the matters of concern to the local authority, to form the view that there was enough there for him to conclude that in combination, the compliance with her medication and care regime for approaching a year, the stable housing, the presence of her sister,
Yes, we have these
and
ones.
so on. These were all factors that he was entitled to and did weigh into the balance to conclude that in this case the children could be rehabilitated but not without risk. And he's able to identify, first and foremost through the making of the supervision order, with the support to be provided. And my order is a slightly different point, but I am instructed that from the perspective of my instructing solicitor who sits behind me, there was a draft support plan, a safety plan provided on the day one of the hearing. And with the supervision order underpinned by the 2-year non-molestation order, that he was able to achieve a proportionate outcome for these children to enable them to move to the care of the mother, because as the learned judge observes, they were in very great need of permanence at the point at which he came to make his decisions. So, my lord, there's probably more I could say, but I think the headlines are that we say the application for permission to appeal should be dismissed because there simply is no basis upon which it could realistically be argued that it's not clear how the judge has reached the conclusions he has. Those are my headlines.
Well, thank you very much, Ms. Watson. Can I say that, at least as far as I was concerned, the Guardian's report was a particularly impressive one in this case.
Thank you.
All right. Is there anything you'd like to say in reply to the headlines that we've heard? I mean, we don't need you to repeat what you've told us. We see where battle is joined.
Yeah, no, thank you, my lord. I think everything's clear.
Thank you. Right. All right. Well, thank you. We'll take the advantage of the break to consider where we've got to consider whether we need to hear any further submissions, having compressed the respondents to headlines. But we'll let you know what the position is at 2:30. Thank you.